Hello, Colorado. Ryan Melner here, personal injury attorney, and today is Trial Talk Tuesday. So I want to bring you another case from last year. It happened in September of last year, and it's from Larimer County. And in this case, actually, there was a pedestrian that was on a driveway, and he got backed over in a neighborhood. And even though the defendant did accept liability for what happened, he disputed the extent of his injuries. The plaintiff had about $53,000 worth of past medical expenses that he claimed in the lawsuit. And then he claimed over $400,000 in pain and suffering. Now, he sustained a neck injury and closed head injury, probably some other things that came up during the trial. But before trial, the defendant only offered $5,000 to settle the case. The plaintiff had demanded $25,000, so significantly lower than what the medical bills actually were, but I suspect that there was an insurance limit of $25,000, which is why they made that demand. And when the defendant didn't pay it, then the case is probably going to trial. So they went to trial on it. They had the emergency room doctor, primary care physician, and a chiropractor that testified in the case for the plaintiff. There were no experts called by the defense, so they were probably just poking holes in the treatment and whether it was causally related to the actual accident. And the jury came back, kind of an interesting verdict. They came back and gave about $51,000 in medical charges for the past, and then they came back with only $11,000 on pain and suffering. So a jury verdict of about $62,000, $63,000. There was nothing for physical impairment, which is another sometimes large category that you can claim in these types of cases. Now, because of the defendant not beating the offer from the plaintiff of the $25,000, the plaintiff can seek costs on the case. So it's likely that the defense is going to end up, or the defendant's going to end up paying a lot more on the case. And in addition to that, there's also interest from the time of the accident. So I could easily see this verdict coming back and the defense ending up paying as much as $90,000 to $100,000 on the case, just because of those two things. Now, in this case, the plaintiff wins, again, because they beat what the defense was offering to settle the case. And there's always an incentive to negotiate beforehand and make offers of settlement so that you can actually protect yourself and win the case, because then you can seek costs after you get the verdict and you beat the defense and what they've offered prior to the trial. So it's a great strategy that we use on our cases, and that's another Trial Talk Tuesday. If you have questions about that, give us a call or shoot me a message.